An agreement between two or more parties is formed when an offer is met with an unqualified assent to it, referred to as an acceptance. This essentially means that no changes to the offer were made by the person accepting it. An area of some doubt, however, is when an acceptance is considered to have been communicated, especially when there are multiple parties that may have sent acceptances to the offeror. This is where the Postal Acceptance Rule takes place. The general rule is that where a person who intends to accept an offer uses an authorized mode of acceptance, the agreement is formed at the time the acceptance is handed over to the authorized person. For instance, imagine the offeror has requested acceptance by post. What this would mean is that irrespective of the receipt of acceptance by the offeror, as long as the offeree hands it over to the authorized person, in this instance the postal service, the agreement has been formed. Whilst this does seem straightforward, the situation changes for instantaneous forms of communication. Imagine the offeror requests for acceptance via email. This is an instantaneous mode of delivery since, unlike the post, the transmission of the acceptance happens within a split second. In this instance, an agreement is only formed when the acceptance reaches the offeror's inbox. To put this in context, consider an acceptance via WhatsApp. In the event the offeror's phone is switched off, you would only see one tick. In this instance, acceptance is incomplete. The moment he or she switches the phone on, the ticks duplicate. It is at this point that the law considers an agreement being formed. The ticks need not turn blue.